would you like to protect your wealth from lawsuits and taxes and much more that could possibly go wrong? Matt Meredith will tell us how to do this. And what's so special about Matt Meredith is he is an attorney, wealth strategist who founded Meridian Legal Advisors, a one-stop shop for asset protection, estate planning, tax strategy. And he is known for creating estate plans that go beyond cookie cutter approaches, building strategies that protect wealth from lawsuits, creditors, and unnecessary taxes.
Welcome to Awakened Titans podcast with Lily Patrascu, mind-blowing conversations with influential business titans sharing how you can manifest abundance, love, joy, success through quantum awakening, quantum manifestation, quantum healing, quantum miracles, exponential business growth, and innovative products and services.
I'd be happy to. Thank you for having me, Lily. I think one of the biggest misconceptions about protection is we don't need to be multimillionaires to protect our wealth. It's if you've worked hard for it, protect it. Whether that's a small amount or a great big amount and you're a multi-billionaire, everybody wants to protect what they've built. And so that's where we come in at Meridian is we take everybody and we say, all right, here's what you have. Let's go protect you going forward.
Great. Tell us about what are the types of things that people need to put in place to avoid going through probate. Let's say that someone has multiple houses and has multiple types of assets. What kind of things do they need to put in place to avoid that? In the case of death, their assets don't go through probate.
Great question. Probate is what happens when you have a will or you don't have a will. So there's getting things out of your estate so that way you can avoid probate. And so a lot of people, for example, they'll go create a business. They'll run this business. Well, the business is ultimately owned by them. And so when they pass away, that business has to go through probate unless there's a succession plan in place or it's owned by a trust. So when we talk about properties, your home, for example, you can't just take over ownership of a home when someone passes away. There has to be probate, or you have had to take it out of the estate beforehand. And so when we talk about probate and avoiding probate, a lot of it comes down to titling. How do you title property properly so that you can avoid the expenses of probate, the time of probate, as well as the mistakes that are made, such as contestation and things like that. And so one of the main ways that we protect people, estate planning attorneys, and especially us here at Meridian, is we build out a system that is going to take the assets out of the estate. A lot of times this is through a trust. And so when you create that trust, it's one thing to have a trust, but how often have we seen people who they have a trust, but nothing's in it? And so you then have to take that next step to get the assets out of your estate. So if you own multiple properties, you have to move them out of your name. A lot of times people own them in a business, so the business has to be owned by typically a trust or something like that, so that it can avoid the whole probate process. And it's really just, it all starts with listing your assets and then going through all these assets and seeing how is this titled and answering the question, if I die today, what is going to happen with this asset?
When is it worth it for one entrepreneur to start putting their assets in a trust? Is it when they start making $1 million or when they start making 100K per year? Or what's the amount that you think actually the cost of setting up the trust and the cost of the extra hassle you might have will be offset by the benefits of doing so?
Fantastic question. I get it all the time. A lot of times people come to me and all they have is their house. And sometimes the question becomes, well, do you really need a trust just for your house? I think when you're looking at a trust, a lot of people assume the trust will protect them. A trust doesn't really protect you. It just organizes things and helps avoid that probate issue. And so when it comes down to when do you create a trust, I always have several questions I ask for people. A, do you own a business? Is this a family business? Is it in your name? Is it making money? Is it something serious? Because if it is, we want a trust at that point to actually be the owner of this business. If you have multiple properties, Probate's not cheap. Even if you're just doing what's called a muniment of title, which is, hey, I have this house, we have nothing else to probate but this house, it's still going to cost a good bit of money, relatively more expensive than what you can get a trust for. When you have other interests, such as, let's say you have children, underage children, and you want to make sure they're taken care of, at that point, that's when a trust starts making sense. Making a trust just to make a trust, here's what happens. People make a trust and they never put their house in it. They never realign their business to it. You have to have a reason, because if you don't have a reason, it just sits there and then you go through probate anyways. But ultimately, when it comes to protecting assets, I kind of mentioned it right at our intro. It's if you worked hard for something, it doesn't have to be $1 million. It doesn't have to be $100,000. It's what you have built you're wanting to protect.
Thank you. I read something in the paper. I'm not sure if you've heard about the capsule that went to see the Titanic, and there was a billionaire in it. And then the billionaire died alongside with his nephew or something. And then I read in the paper
I
that
remember.
his wife was left with only 100,000 pounds or something because she was living in the UK. And then somehow the wealth that he had was mostly in Pakistan. And I didn't quite understand how that was even possible. So tell me about families that own properties and assets in multiple countries. What can they do to protect that wealth so that they don't end up in a similar situation where the wife, let's say, the survivor wife is left with nothing?
Great question, one that I respond to all the time. So my wife is from Mexico. She is a Mexican citizen. We don't own property in Mexico, but there is a goal to buy property as time goes on. So here in the US, law itself is jurisdictional. That's the word we use for it. So the laws of the United States, and even so much where I'm from or where I'm living in Texas, are different from other jurisdictions. And so when you own properties in other countries, you have only really your setup for the US in the US or in the UK. So you need a separate plan for every jurisdiction you're in. And so I wasn't familiar with the widow of the guy. I think it was the Deep Horizon is what they called the submarine. But what would have been done in proper planning is, okay, you have your assets in the UK or wherever she was set up, but then you also have your plan in Pakistan where a lot of his money was. And so when you're setting up something, typically we're just doing US type stuff. In particular, we do a few states, Texas, New York, some other states, but we're building out for there. So if you own, for example, let's make it easier. You own a house in Texas and you own a house in Louisiana. Well, you create a plan in Texas and you go and do what's called ancillary probate in Louisiana. But because we're all connected under the 50 states of the United States, it's called ancillary probate because they allow you to take that estate plan and move it over and make claim to the properties. But other countries may not allow it. And so when I talk with a lot of Mexican citizens and they have property over here, they don't realize most times that, hey, whatever you have set up in Mexico is not going to protect you in the US. You need a separate plan here in the US because we have different laws. Mexico is Napoleonic law. We're more British common law. And so therefore, you have to follow the rules of all the jurisdictions you're in.
Thank you. For common bank accounts, for bank accounts that let's say you have shared with your wife, what do you need to do? Because I think I read somewhere, I think it was in TikTok, and it was mentioning about you need to set up something like pay upon death, kind of bank account that allows you to benefit from, the common money once the person you're sharing the bank account with passed away, because otherwise it could be very complicated to get hold of that money. It could take, I'm not sure, years, but definitely a lot longer. And I'm wondering, is that like a good technique to use? And if yes, tell us some other techniques that are really important to set up so that your money doesn't get, stuck for years in bureaucracy and other, you know, horrendous things that tend to happen because you didn't put things in place.
Absolutely. There is few things that are worse than losing somebody and then having no access to the money to keep moving forward in your life. And that is one of the first things that we discuss when we're dealing with clients is how are your banks set up? How are your brokerage set up? So I spent probably 10 years in the banking industry working the wealth management side. So I worked for JP Morgan Chase, Capital One Investing. I did a little bit of a credit union as well before going completely independent. And one of the things when you're dealing with a bank account is you pick a beneficiary. So these are things that bank accounts, investment accounts, these are things that pass by contract. So it can avoid probate by having a contractual agreement. So for a bank account, it's called a payable on death. And so you list your beneficiary. So in most cases, if you're a joint account holder with, say, your spouse, what's going to happen is if one of you passes, the spouse will take over the entire account. Brokerage accounts are a little bit different unless they're joint accounts. So again, the other person would typically take over if it's joint with rights of survivorship. But you're also in a brokerage account, you're picking who your beneficiaries are. And so in a brokerage account, it's not a POD, it's a TOD, a transfer on death. And so what we're doing with these accounts is we're picking by contract who's going to take over this account or, well, who the beneficiary is if something happens. Now, when you build out a trust, what you typically will do, and what we do a lot of times is, okay, everything I own if I die, contractually will go to my wife in the accounts. But what if my wife passes away at the same time as me or before me and I never update it? In that case, it will go to my living trust that I created because that living trust is going to distribute according to my desires that I built out. So again, why you're using a trust versus a will is when you have a will, you can still distribute things to people. It has to come in through the state, but everything's public. And so if you're giving money to a child, let's say, hey, I'm going to give $100,000 to my nephew. Well, this is public. Everybody's going to know that my nephew has $100,000. So I don't want that to be seen. That's why we use these things such as trust, or we'll go straight to the bank and we'll set up a POD or investment account TOD. Life insurance is the same way. You're picking who the survivor or the beneficiary will be. And if that point, if my spouse isn't there, it comes into the trust and the trust can distribute it according to my terms, which may be, I don't want to give somebody 100,000. I want to put it in a contingent trust until he's of a certain age. And so it's more control.
Thank you. Tell us what happens and what should be put in place for a case where imagine you have a business with a business partner, and then your business partner ends up being invalidated. Not invalidate. What I mean is disabled in a sense that they
Mhm.
cannot speak, but they are still alive. Let's say the situation happens to your spouse, and then you have a joint bank account where, let's say, if you wanted to take a loan to help with whatever condition they had, you would have to have their signature, but they can't do it because they're actually not well enough to do it. What would need to happen? What steps could you put in place to make sure that you still have access to the money, you still have access to the same benefits you would have if they were able to sign for whatever you wanted to sign in terms of the bank loan or whatever it was, so that you can move forward in that situation?
Perfect question. And what we're dealing with here are really different situations. So let's take husband and spouse first. So typically, when you go to the bank, let's say you need a loan, you can take that loan out as an individual. You technically don't need your spouse to sign on it, even though you're joint owners of the bank account. They're not going by your bank account, they're going by your credit score and your net worth. But let's say your wife has a bank account that she's only on. And so she has payments, and those payments need to be created. In estate planning, we create something called a durable power of attorney. This durable power of attorney is a financial power of attorney. So, for example, I've got multiple businesses, my wife has multiple businesses. If something happens to me, somebody needs access to the money. Some people have to be paid, bills have to be paid, things have to take place. Well, this durable power of attorney gives my wife the authority to act on my behalf. So she would take this to the bank and say, hey, look, Matt has several bank accounts here. I need to have authority on them. I'm his durable power of attorney. For businesses, it's a little more to it because the business is its own separate entity. Now, you can write into a durable power of attorney, this person has the authority to work. But let's say you have multiple partners. Let's say you and your mother own a business together and something happens to you and I'm the power of attorney. Do you think your mom's going to be like, oh, yeah, you have access to all of our bank accounts? Absolutely not. And so, what has to happen is you have to set the business up with what's called succession planning, and you have to have some agreements made within your operating agreement, is kind of where you put this that, hey, if I become incapacitated and I have a business partner, this is what's going to happen. All of this can be built in, but most people don't think about it. And so if something does happen, the business has a problem because let's say only one person had the bank account. Well, how does the other person get the bank account access? And so a lot of planning goes into it, but typically what you're writing is financial powers of attorney for people.
Thank you. So, are you saying that if, let's say, the business partners hadn't thought, or the business partners or the spouse hadn't thought about this solution, what would happen in this case, where only one person owns the business, only one person has the bank account access? What could possibly go wrong? Can you get this power of attorney later, or you can't, even if the person that you have a business with is currently incapacitated, for example? Can you do something post, this happening, or no?
The answer is yes. And typically, us lawyers love this phrase. They teach it to us in orientation on the first day. The phrase is, it depends. And you've probably heard lawyers say this all the time. It all depends. And here's the situation. So let's say there is a bank account or just everything in life, everything financial, the financial side of it. And something happens and you don't have these estate plans in place where you have a durable power of attorney. Well, once the person is no longer capable of signing, you can't get one. And so people will reach out to me all the time. Hey, I need a medical power of attorney, or hey, I need a durable power of attorney. My mother's on her deathbed. She's no longer cognizant, she's no longer mentally competent. Can you come do it? And the answer is no. Once the person loses the cognitive ability to do this, we can't help them. So, what's the alternative? That is usually what's called guardianship. So, you can go get a guardianship of the person, which is protecting the person, handling the person's affairs. So, where they live, what they're eating, who's in charge of taking care for them, or you can get a guardianship of the estate. The estate is the financial world of this person, so bank accounts and things like that. But this is a whole process. You have to go into court, get a guardianship set up. The court has to approve it. You have to select who's in charge of it. And then you're given the right to handle the ward. That's what we call the person who is incapacitated, handle the ward's estate. And at that point, you can take these powers or these letters basically to your bank and say, hey, look, John is incapacitated. I'm his spouse. I'm going to hand you these documents, and then you would be able to take over that account. So it's a very drawn out process, and that's why it's very important that get this taken care of before it's too late. A perfect example, somebody gets in a car accident, they don't have durable power of attorney set up. There's no way they can sign. There's no way that you can really get access to the bank account very easily. And that's why it's so important because we don't know. I could get hit on the head walking the dogs this very night, and then it could be problematic.
Thank you. Tell us your 10 commandments for protecting your wealth from lawsuits and taxes and other hassles. What kinds of things should someone put in place?
Ooh, 10 commandments. I can probably give you a few. And the first one is to be aware. Be aware of what you own. Be aware of what's at risk. The next one would be overconfidence. A lot of people, they set up a business and they think, hey, I'm protected. It's in its own LLC. If I get sued, everything's fine. Insurance will cover me. But the problem with that is we see it happen all the time. Lawyers are able to pierce the corporate veil, as we call it, and get through that company and get at personal assets. So when you create a company, don't be overconfident that, hey, I've done everything right. A lot of times people will create the company, they don't create operating agreements, or they do what's called commingling, which is I'm using my business money to pay for things that are in my personal life. And I always use the example of, okay, I'm going to Hawaii with my wife and my company's paying for it. Well, if it's not a business trip, then the company should distribute that money to me first, and then I pay for it as though it was my own money. I was paid for my company. Because when you do these type of things, you create problems. The the other thing when we talk about taxes, get your taxes in order. There's a huge difference, and I always use the word huge, and I stretch it out because it's huge, between accounting and tax strategy. Accounting is looking backwards. It's like taking a history report, where strategy is you're writing your history. So these people who are paying a lot of taxes, they go to a CPA, they talk to them, they basically just, okay, this is what you spent, these are your expenses, here's your taxes. Well, that's not proactive. That's just looking back at what you've done in the past. The difference between being proactive and creating strategy is we're looking for ways to cut taxes legally. We're looking at types of investments that you can make that have depreciation in them, types of companies that you can create that have, different types of tax strategies. Everybody talks about the S corp election. Well, S corp election allows you to save money in employment taxes, but you have to do it correctly. And so there's all these different things when we come to tax strategy that must be done properly. Another thing, another commandment that I it's basically own nothing, control everything. And I hate using that word because I call it a cliche, but that's what it is. Don't have things in your name. I always tell the story of the guy who I had doing investment management who retired, had this huge brokerage account. It was all in his name. He goes out, plays golf, comes home and hits a school bus full of kids. He gets sued. They go after that account. They get a judgment against him. Don't let that happen to you. Structure things properly. Don't keep large assets in your name. Create holding companies that are owned, or create a holding company that owns other companies so that there's layers of protection built into it. Because when you have these layers, let's say there is a little bit of commingling, there's still another layer of protection up above that. And so you kind of combine these things together with one another. They're separate disciplines, but they all work together. We've already talked about the estate plan. The importance of having an estate plan is very simple. It's to control everything into the living trust. So the living trust owns the holding company. The holding company owns the individual companies underneath. And now you're protected. You're working a tax strategy. And if something does happen, let's say one of your companies is sued, it's contained in there. Or let's say somebody sues you personally, well, it's just contained around you personally, but you don't have these assets. So that's about seven of them. I could go on, but I feel I talked too much already on that one.
Thank you. Now, imagine someone who already owns 10 properties in their name. Can they transfer this to a trust now? Or how would you recommend someone, let's say, someone to do it well? Is it that they would start to buy a new property in the name of the trust? And if so, like, isn't the mortgage and so on more expensive if you buy it with a company and harder to get?
So there's multiple ways to do this, and we do a lot of real estate and investment protection. And so let's take an example of a guy who has three or four properties. Let's just say four. The way a lot of people do this is they create an LLC, and that's their investment company. And so they'll buy all these properties in this one LLC. Well, the problem with this is if you are sued, let's say somebody falls through the house, or a renter sues you because they're not happy, or a contractor sues you because there was a disagreement. Well, everything in this LLC bubble is up for grabs. So the way that it started to become when it's done correctly is let's separate each property out. So in certain states, what people will do is they'll create one LLC for each property and everything's owned up top by typically a Wyoming LLC or other type of LLCs. And the reason you're doing this is you're building in anonymity. So we don't want people to know what we own, so we want to own them anonymously. So an anonymous holding company comes in, owns each LLC. In states like Texas, what you're able to do are things that are called series LLCs. Not every state has this, but a lot of states do. And so what the series LLC is you have your parent company, which is like a holding company, and it has subsidiaries that break down. So we'll call these children. Each subsidiary owns a piece of property by itself. Each subsidiary child has its own kind of bookkeeping, but everything flows up into the parents. And then if you want to become anonymous, you actually have that Texas Series LLC owned by a Wyoming LLC or another one that would do the job. And so now you're separating each house from each other. But this is just on the asset side. You also have an operations side. And so when we talk about being sued, a lot of the types of lawsuits that come are through the disagreements that are contractual. And so for somebody to sue you over a contractual agreement, they have to have privy to it. But if all your assets are in a holding company that isn't doing business, it's very hard to sue it. So what do they sue? They sue an operating company. So you create a second company called an operating company. This operating company is the one that makes the agreements. It does all the business associations with these properties, such as renting it, such as getting roofers, contractors, things like that. So if there is a problem, the lawsuit happens on the operating agreement side and your assets are protected. So that's a mouthful of words for you. I hope you understood kind of what I'm saying. Separate the risks, separate the business, separate the assets.
Thank you. I have actually a friend who's doing exactly that. But one interesting thing that I learned of recently was that there was a guy that told me that he had a problem with a smaller company that he found out was owned by a larger company. And I'm wondering, how do some companies stay anonymous and others, like, clearly he found out who, that bigger company was. So now he said, "Oh, because of this, then I can sue them for $1 million." And I'm just wondering, like, what can be done to remain anonymous and actually not allow people like him to sue you.
Well, again, to sue a company, you have to have privy a contract with that company, or that company must have wronged you. A lot of times these structures are set up to where, using the example of a Wyoming LLC, Wyoming LLC is used for multiple reasons. It's very easy to do business in Wyoming. They built it like this, but you don't have to list who the owners are publicly in Wyoming. And because of that, when people go to look who owns it, there's a blockage. It doesn't mean it can't be figured out. For enough money, somebody will figure this out. It just makes it harder. And if it's harder and you don't know if you can sue it, and you come to me and say, "Hey, I want you to find out who owns this company." I I look at them and I say, "Well, it's going to cost you money." And if I see it's owned by a Wyoming LLC, the price goes way up because there's a lot more work involved in it. So it's a block to smaller type lawsuits. But if somebody died, let's say somebody died and there's a court action going, a lot of times the court will come in and say, "Hey, tell us who owns this company." You can't hide everything forever, but you can make it so that it's much more difficult to get there. But again, if the court says, "Show me," you're gonna show. So another way that people own things anonymously is, for example, you could own a Texas Series LLC through an agent type setting. And so what you're doing is you're having someone else manage it. And so we would use a trust. We would build out a trust for this, and the trust would be listed as the manager of the Series LLC or the Texas LLC, and trusts aren't public. That's the beauty about them. So if I look up, hey, who is running this company, who's managing it, I'm going to see the name of a trust. So let's say we have 123 Corporation. The trust that manages it will be the 123 Trust. So all I'm going to know is, hey, this is owned by a trust with the same name. And so you're building in that anonymity where it takes a lot more work to figure out, hey, who owns this?
Thank you. Tell us about the types of things someone should put in place for estate planning. So, for example, is there like a checklist that you would have where people would need to kind of do a scan all of their like birth certificates and I know house files of all the different house ownership files, and are there a specific thing like passwords for Facebook, and I know, is there like a checklist of things you put in place for people who want to have the proper estate planning done the right way?
There is. And this comes back to when you start this process, one of the first things we said you have to do is sit down and figure out what you own, how you own it. So we send a questionnaire out. My questionnaire is going to ask you about brokerage accounts, bank accounts, properties, investment properties, everything you have, crypto. I don't ask for the social media because everybody has it. But when it comes to social media, it's where's your list of passwords? And it's not just social media. You might have QuickBooks. Everything is online now. Where is your list of passwords? This needs to be available so that people can get in and do certain things. But the questionnaire itself goes into a discovery and it helps you list and understand what it is you own going forward. And so that's one of the main things that we use to figure this stuff out.
Thank you. Tell me about anything that needs to be put in place for your phone. Imagine someone in your family dies, and then you might have all the passwords, but if someone dies, like what happens to their phone? Because normally you need their phone to access all the different, like Facebook access and QuickBooks and all these different things. A lot of them need like a two-factor authentication. So what needs to be put in place for you to have access to someone's phone? Like, does the phone stay continue to be live, or like what do you need to put in place for there?
It's really kind of up to everybody. And so I have, two-factor authentication on most of my programs. My wife already knows my password to my phone, so she's able to get into it. And I think in most cases, especially between spouses, you already know. I know how to get into my phone, my wife's phone if I need to, but let's say you don't, then that becomes something that we have a conversation about during the estate planning meeting where we're going over all this. It's not just about the assets at this meeting, it's also who's in charge of handling these things for you. Because if you're picking somebody, say a cousin, who wouldn't have access to your phone, wouldn't know the password, then we need to prepare for this and make sure that, hey, we have access to this person. And then you can handle the estate at that point, keep paying the phone bill and then shut it off when you need to. But once you kind of get access to it, a lot of this stuff, you're not continuing to use Facebook. You're pretty much getting on there and you're scrapping it. Same thing with most of the social medias. A lot of the other type of things that we would use are utility bills. So you're going in there and you're shutting off services and you're making phone calls. A lot of the companies in this world, they understand people pass away and somebody's been stepping up to handle this for them, and therefore they make it a little bit easier. And then again, the court will give you the authority to go in as an administrator or as an executor to handle these type of things.
Thank you. In cases where entire families get wiped by, I don't know, a car accident or airplane accident or some sort of thing that was unexpected, where let's say the family did have estate planning in place, but they only thought of, their children or their children's children and so on, and then let's say everybody died, as an extreme example, what would what needs to happen from an estate planning perspective? Is it that you kind of choose 10 different potential um people to inherit this, or like how do you mitigate this kind of potential risk? I don't know, it sounds ridiculous.
No, no, I love your question here. I'm thinking, wow, you really thought this one out. This is normally a question that I ask somebody is, hey, what happens if you all pass away in a ski trip in Colorado? What's going to happen? A lot of times, which I think is more the common thing, people will choose their heirs. And so these are, let's say me and my wife passed at the same time. I've chosen people who get things instead of her. But well, let's say we're all on a huge family trip and we all go. Well, then it goes to your heirs. So typically an heir for a person, you have your descendants, which are your children going down. And then the heirs, I like to say the heirs go up. And so my heir would be my father. So if me and all my beneficiaries passed away, my father would inherit everything because he's listed. And from there, it branches off to siblings. And if there's no siblings, it can go to aunts and uncles and things like that. But because we asked this question, we already planned for it. And so a lot of people, I hear it all the time, will give my money to a charity. If everybody dies, give it all to charity. And so we'll build out the estate plan to have that person or that charity accept it.
Thank you. What tax strategy should someone put in place that you can say most people need to be thinking about these kind of things or need to be putting this in place and it will work for most people? And I do understand every single person needs to have like a tax strategist to advise them personally for their custom situation, but are there any specific things that most people could benefit from aside from everything
Definitely.
you've shared already?
One of the things we do here at Meridian is there's what we call a tax advantage. And so we take a look at what you're currently doing. Give us 2-year returns, and we're going to look at everything and we're going to see where you're making contributions, IRA accounts, HSA accounts, the little things that you could be doing that's a little bit better. And so this will save some money for people. When you get into actual strategy, in order to have strategy done, you have to be making enough money to do certain strategy things, which means you have to be paying X amount in taxes. If you're only paying $4,000 in taxes, it doesn't always make sense to go hire a strategist who's going to cost you several thousand dollars, and then you're going to have to find these other type of investments to get into and these other strategies. So normally it's typically you're paying $20,000 in taxes for you to really start making sense to get into it. But for everybody below that, it's really let's find assets. Let's see what you have available so that you can go in there and start buying things that are building assets for you that can also lower your current taxes, such as short-term rentals. Airbnbs have huge deductible ability. People like real estate because you have depreciation, you have costs, you own the asset, but the asset itself has expenses to it as well. And so a lot of things depend on how much time you're able to spend in real estate. And if you can't spend and become what we call an active participant in real estate, then it becomes, hey, maybe we can do these short-term rentals or depreciationable plays, oil and gas, things like that, that can help lower it. But it all starts with the very simple. What am I doing now? And can I do what I'm doing now better? And if I'm paying a lot of taxes up to that, hey, over $20,000, then a lot of times we can come in there and cut that down substantially while we're building the net worth.
Thank you. Tell us where entrepreneurs can connect with you.
Definitely. We have all the usual social media. So LinkedIn, Facebook, Meridian Legal Advisors. We're there. We have our website, meridianlg.com. You can always grab our information on there and reach out to us. And you can always reach me at my email, matt@meridianlg.com.
Thank you. And is there any particular jurisdiction that you have that you can advise people in, or?
Definitely. Right now, I'm currently well, and for attorneys, you have to be licensed in the state or have an attorney in that state. And so currently, right now, we're working with Texas residents, New York residents, Missouri residents, and North Dakota residents. And so as we grow and bring on other attorneys, we're able to expand out to these other states. But right now, if you're in one of those states, reach out to us. We're happy to help you.
Follow us for more interviews with world's most influential business titans, providing you with the insights to awaken to your full potential so you can get paid to be yourself, find true happiness, and manifest anything you desire.